Back to our regular drawing board. Here we shall discover a dialogue between two internationally renowned attorneys. These attorneys will be illustrated in our segment called Focus on Health Law, which is a proud presentation of attorney Kenneth Haber from Boyd's, Maryland. The moderator on this set is attorney Ramesh Khurana, who is the chief attorney at the Khurana Law Firm. This morning, attorney Khurana questions attorney Haber about the different types of OIG exclusions and how long can an exclusion last. Let's take a closer look.
This is Ramesh Khurana, attorney at law. I have my office in Gaithersburg, Maryland. I am very pleased to welcome Ken Haber, my friend and a very experienced lawyer. Welcome.
Thank you, Ramesh. Thank you very much.
Always a great pleasure to see you here.
It's my pleasure.
And especially when I ask you questions, I learn in the process so much.
Well, I appreciate that. I appreciate that.
This is just the benefit of your very rich experience. You know, Ken Haber is the former assistant U.S. attorney, and he's the former senior attorney in the office of Inspector General. So he has handled healthcare related topics for so many years. And that's why we have the benefit of his presence in our studio while asking different questions. So Ken, today I am going to ask you questions about OIG exclusions. First of all, before we begin the topic, just simplify. What is an OIG exclusion? Can you please explain for me?
Sure. An OIG exclusion.
You are always very kind.
Well,
you always listen to me.
Thank you.
Thank you.
Thank you. An OIG exclusion is a mechanism where individuals are identified so that they are not permitted to participate in the Medicare and Medicaid programs because of communications that go on nowadays. They're not permitted to participate in the Veterans Administration programs. They're not permitted to participate in any of the government non-procurement programs, healthcare programs, and for the most part in the government procurement programs because they'll check out those lists too, and they no doubt would be prevented from participating. The exclusion does just that, excludes them. It prevents them from participating.
Okay. Now let me ask you another question. What effects does an OIG exclusion have upon an excluded individual or entity?
It prevents them not only from participating themselves, like a doctor, you know, cannot participate in Medicare, Medicaid programs when he's excluded, but it has a bigger effect. He cannot work for somebody
because he's excluded.
Because he's excluded, so he can't work even as an administrative function for somebody normally who is a healthcare provider that's billing the government. So if you have a doctor's office.
So his administrative functions relating to the billing part of the government only, right?
It's not even that. He couldn't be, put it this way. The way that the different healthcare providers interpret it, various institutions interpret it, and no one wants to go against the IG's office in terms of trying to find out the hard way, although I think that if something was tailored in an advisory opinion in certain respects that they might even approve something, but without something like that, which defines an exception, that you couldn't be the janitor theoretically in healthcare. Now, are you saying that the buildings that they have, that they checked them out? No, I'm sure that they probably don't check out the janitors in the large buildings that have multiple offices and everything. But the IG's office doesn't want people being in the offices of the providers. They don't want them to be involved in the billing practice. They don't want them to be involved in the practice of shuffling papers or anything. They don't want them to be in any of the areas that could possibly affect the programs, and they enforce their exclusion. So if somebody hires somebody who's excluded, the IG's office come in and say that we're excluding you because you're employing an excluded person. If a
very severe penalty, right?
Oh yes, and not only that, if you own an excluded entity, you're subject to being excluded. I had a case once where an individual had a good attorney, and the attorney was the criminal attorney, and the attorney was able to get the government, the prosecutor, to prosecute only the corporate entity and not the client. And the corporate entity pled and had a felony, and both the corporation and the individual were sent notices that they're being proposed for exclusion. The individual, because he owned the corporation, and that it was a related entity to him, and that he was being proposed for exclusion in that. And his attorney was writing, because it was a permissive exclusion, not a mandatory exclusion, his attorney was writing all these nice letters saying how good he is and all these sort of things, and sending it off to the IG's office, and the guy thought maybe he should get the opinion of somebody who knows what's happening. So they contacted me, retained me. I contacted the IG's office, got a little more time to put together a presentation. And what we did is we took the corporate entity and we put it into a trust. And it was a dead entity. All it had is receivables. So it was put into a trust. A totally different individual was made the trustee. And
you mean not related to the
not related
physician.
to the physician or the provider, not in any way related, and the beneficiary of the trust was the government. So anything that was brought in was going to go to the government. And
very good tool, really.
so anyways, we submitted that and said he's no longer related. He was the grantor, obviously, but he's not the trustee. He's not the beneficiary. He's got no interest in it anymore. He already gave it away to the trustee.
Leave him alone.
Please leave him alone. Well, I mean, the fact of the matter is that he was no longer related to the entity that had the felony.
Right.
And they excluded the entity and they left him alone. And
this is the benefit of hiring an experienced and knowledgeable lawyer whenever you are in trouble.
Well, it's very much a matter of just being able to sit down and figure out what you can do, because of the fact that these things are so complicated, and that's what was meant to be, I'm sure, or else it wouldn't have been. If those things went through the way his attorney, original attorney, not the criminal attorney, he did a fine job, criminal attorney, where he avoided him getting prosecuted, but the attorney who, I don't know what type of attorney was, but he wasn't a healthcare attorney or wasn't an IG type of attorney. If it went through his way, the guy would have been excluded because he was associated with a related entity. It's that simple. And,
no, let's move on. Let me ask you one more question. What effects does an OIG exclusion have upon you concerning other government programs and private insurance payers?
Well, that is, the $64,000 question. And
why not $100,000?
Okay, $100,000. For the government programs, it's going to keep you out of those programs too.
Oh, okay.
Now, the private insurance payers, in most parts of the country, it's going to keep you out of them because of the fact that they want to march the same tune.
Right.
If you're in some rural area, where they don't have anyone doing your specialty.
You mean medically underserved area?
A medically underserved area. That private insurer might very well keep you in. the interesting thing is the IG's office has a provision that they're expanding. They've got proposed regulations where they have waivers. And they're expanding the waivers so it's a little easier to procure a waiver, but it's for the purpose of being able to provide specialized services in areas, and it doesn't have to be rural. It could be urban areas, because there's underserved urban areas.
Yeah.
And it's to be able to provide services to these underserved people.
It makes sense. Yeah.
And it takes a request from either the director of Medicaid or director of one of the other federally funding programs that provide funding for healthcare. And the interesting thing is that it's just like the private insurance companies might decide that they're going to let somebody continue on, even though they've been excluded from Medicare, because they need that person's experience and they feel that they can manage the situation, not have him do any more frauds or whatever. And just like the IG's office with the waivers, they consider that this person's not a threat to the programs, that services are needed, and they're going to, let whoever is requesting it, such as the director of Medicaid, take the responsibility to make the request. And for the most part, if it's truly underserved, if it's truly where it's a specialty that's not going to be provided otherwise. And this could be linguistic specialty too. I had a client who spoke Spanish in a rural area where they had a lot of Spanish transient patients. And we had fought the exclusion tooth and nail in the 80s or early 90s. And fought the IG's office, obviously. And we went up to the U.S. District Court even, and we lost. And we turned around, we applied for a waiver, and they granted it because of the fact that they were trying to do what was right. They felt he should be excluded, but then we were able to get the request from the director of Medicaid at that time from that particular state, and they granted the waiver. So,
so you have to use different available tools to accomplish your goal.
Yes, and they have a multiple number of goals that they have to juggle.
Right.
So it's a difficult job they have.
Yeah. Now, let's say that exclusion has taken effect. Is there any time cap up to which is going to last?
Yes, they set that. And you can appeal it if it's beyond 5 years as a mandatory, and if it's beyond 3 years as a permissive, you can appeal it to an administrative law judge. The Inspector General's office has in regulations different factors that can be considered for mitigation, certain factors that can be considered for aggravation. And if they discern that there's aggravating circumstances, they could put it up for 20, 30, 40 years exclusion if they feel that that's appropriate. The ALJs normally defer to the IG's office nowadays. Since the 1990s, and I think it was 92, regulations that came out and changed the balance of presumptions and such. And so you have to have a really good case before they're going to change an exclusion determination that the IG's office made in terms of years. As far as whether it's mandatory, if it is conviction on a program related issue, then that's a 5-year minimum. And if it's a permissive one, that's a 3-year minimum. Now, if in fact on the permissive you come in with extenuating circumstances that are within their guidelines, you might be able to convince them when they're first imposing it to be less. But it all depends on what the facts are.
Great. Now let us say that OIG had decided to exclude a physician. Now, what are the appeal rights available with the physician against the decision of the OIG office?
You go to the department's administrative law judges. It's not the It's not the ones from OMA who have 700,000 case backlog. It's the ones who are with the Departmental Appeals Board, which is the Departmental Appeals Board's attorneys, the judges. They have a section in there that handles these.
Okay, great.
Just flew out of my mind the initials.
Right, no problem. Now we are just left with 15 seconds, Ken, but I must thank you for coming to our studio and answering our questions. Thank you so much.